Okay. Good morning, folks. I am so grateful to all of you for jumping on a call so suddenly and early in the morning with all of the other work that everyone has going on. I really appreciate y'all. I you know, folks are here because you probably received my email. But in case you're new, we haven't had a chance to meet. I am Jill Martin Diaz. My pronouns are they, them. I am the executive director of Vermont Asylum Assistance Project, and we are a newer legal services organization that are trying to increase the capacity of the immigration defense bar here in Vermont. I'm joined by an incredible staff and many volunteers and many community partners, several of whom are on this call. The purpose of this call is to fast track the launch of a detention defense program that we've been working on behind the scenes. We were planning to launch it for later this summer. And unfortunately, the pattern and practice of immigration customs enforcement activity in Vermont has escalated this week to a point where I don't want to hold you up as the legal advocacy community. If there are tools, if I can invest an hour and a half right now to give you some tools to kind of get going with being able to provide some legal response in facilities, I want to do that. And so the spirit of the training this morning is to orient you all to the issues, update you on what we're thinking about in terms of a legal response, to crowdsource information about how we can set up infrastructure to make this a successful project, and just like get to know each other a little bit. And then for folks who are intrepid and willing to learn by doing, who don't take themselves too seriously and are okay with making mistakes like me, who might be willing to press print on some screening packets and know your rights packets and actually mobilize to the detention facilities today for the purpose of trying to provide at least some minimal legal orientation to folks we know who are detained in Vermont corrections facilities right now. I will say up front, for me, success looks like getting the conversation started, mobilizing, crowdsourcing information, agreeing on next steps, and maybe deploying a few people to the facilities where we know people are held right now. Success to me does not I am not envisioning or measuring success according to whether or not people are actually able to have confidential one-on-one attorney-client meetings today in facilities. It is logistically complicated to visit facilities, especially for folks who are not licensed in Vermont or who are not licensed attorneys at all and are interested in appearing on behalf of or under the auspices of VAAP as a legal worker volunteer. It's touch and go, creating language access in detention facilities for people who can't, for languages that aren't servable by in-person interpreters. Like there's many Spanish and French speakers in Vermont, but what about speakers of other languages? Can we get a phone in to be able to pay for telephonic interpretation? Those kinds of logistics. So I think that my call to action for this group today is a hope that you will consider taking a couple of hours to make a trip either to CRCF, the women's facility in South Burlington, or Northwest in Swanton, Vermont, where we know people are being held. Or if you're in the Upper Valley, I understand that there's currently a detainee being held at Springfield, and at least making a good faith effort to try and go to the facility and then gather information, even if the information is just about your experience of trying to access the facility, and share it back with us, because we are just in an information gathering stage. And I think that even this exercise alone today is going to take us a good way along our journey of mounting a detention center-based removal defense program that Vermont has never had. We're so lucky because many other states and municipalities have already done this, and people who have worked in those systems do work in Vermont. So we've got good bones. It's also like we're already in touch with a lot of people in power, policymakers of the Department of Corrections and key lawmakers on key committees and the defense bar and all different kinds of stakeholders, community organizers. So know that this is the first of many conversations. And for attorneys who are members of the Vermont Bar Association, we are delivering a continuing legal education through the VBA on Monday, June 16th at 1 p.m. on Zoom. Immigration Bond Practice 101, tools for seeking administrative remedies for people being detained by ICE. And so we're hoping that attorneys and legal workers who are authorized to practice before the immigration agencies will join us for that training, so that in the future, the goal of an intervention like this will include potentially agreeing to represent someone in their bond proceeding, in their request for release from immigration custody. So that was like a quick overview and table setting. The only other housekeeping thing I'll share with you all is that the information I'm going to reference today lives on our website. If you're not familiar with our website, it is, I'm sharing my screen. VAAPVT.org. It is undoubtedly the best, quickest way to get answers to most frequently asked questions. We are absolutely overwhelmed with communication volume, and many questions can be answered on your own on our searchable multilingual website. And notice that the attorney library, as well as the community library, is a resource that we've been building out over the last many months. Shout out to the amazing undergraduates at University of Vermont who are helping us build that out across many departments. Here, under the tab for bond practice, is where we are collating all of our resources, templates, learnings, protocols, everything pertaining to a detention defense effort. What it would look like to go into Vermont facilities to do legal work. And then if we are able to offer legal representation on a request for bond, resources to help guide you in doing that pro bono work, which VAAP can supervise and support you with through not only supervision and resources, but also malpractice insurance coverage. So final housekeeping note is that I am using Copilot, which is AI integrated into Microsoft. So it's under our confidentiality umbrella because it's tied to our SharePoint to record this meeting and also to generate a transcript that I'm then going to use Copilot to draft a summary of, so that we can help get the information out to other folks. And if you don't want yourself recorded, turn your camera off. I'll talk to myself weirdly. And if you are willing to lend your face, you get used to lending your face. I gave up my privacy some months ago, and now I just live like this. And it's definitely helpful in meetings when folks are able to be camera on, so that you can get like some kind of feedback and energy from the group. So thank you to those who are willing. For anyone else, yeah, if you need to jump off because you're not comfortable even your name being on here, that's totally fine. Know that we're recording and we're going to try and make this available in other ways. Any other housekeeping concerns, anything? I recognize all of the names that are in the participants list. So I'm not concerned that there is currently anyone from the Department of Homeland Security on this call, but for posterity, you are not welcome here. If you are from the Department of Homeland Security, please sign off. This is a place for legal advocates and legal service providers to strategize together. Okay. Any questions, comments, concerns before we start talking about what happened this week? Okay, great. So we Heard in the last 24 hours, there's been two major ICE enforcement activities here in Vermont. One happened yesterday. It's an evolving situation. We were called for help by a representative of the construction industry to let us know that now 10, correction is 10, not 11, 10 people who are subcontracted construction workers in the Newport area, somewhere around Orleans County, were picked up by ICE and taken into custody. And we've been watching them get booked slowly but surely into the Northwestern State Correctional Facility in Swanton. And we don't the employer has security footage that indicates that the arrests didn't happen at work. And so it is not what I would call, or what people would commonly refer to as, a workplace raid. Instead, it seems like it was a group of people that maybe were staying together in co-housing or shopping together at Hannaford or whatever, existing as a group, and custody by ICE. I'm just going to pause so I can welcome in this number and just ask them to identify themselves.
Hello?
Greetings. Hi, this is Jill Martin Diaz of VAAP. I see that a 917 number just joined. Can I ask you to please identify yourself?
Jill, it's Becky Wasserman. How are you?
Oh, hi. Welcome in. To Newport. So yeah, we don't believe that it's a workplace raid. And I think that's an important detail, because when we speak callously, like quickly, and non-specifically about workplace raids, I think it can have the unintended effect of exacerbating fear mongering. It can have a chilling effect on people's ability to go to work. It can have a chilling effect on employers' ability to welcome people to work. And we don't want to be throwing around, we want to be as specific as possible when we're talking about enforcement activities, so that people have good information with which to make decisions about their daily lives. And I would not want to deny anyone access to their income potential today, because we are fueling the fear mongering that the Trump administration has been designing and cultivating for months. We know the people who work together were detained and are now being booked. We at VAAP, our community agreement is that intake is on pause. We all are trading, taking leave throughout June and into July. And so we are not able to offer representation on any new bond cases until our leave rotations are over, in order to do diligence with our existing attorney-client duties. But so we're not going to be able to, represent these 10 people in their bond cases. But we are here to help support anyone here who is feeling able and willing. And I know there's some people on the call who have done this work. And so, fair warning, I'm going to ask you to unmute soon and share about your experience, Brett and Seth. So what happened then this morning? I couldn't sleep because I was amped, and it just so happens that there were some legal observers staked out outside of CRCF, the women's facility in South Burlington, because they got a tip that ICE was going to relocate a van full of detainees to a flight to be transferred out of Vermont to another place. And it seemed like an information gathering opportunity. And so these legal observers let me know that they were doing this, and I happened to be awake. And so we've been texting and talking all morning, since about 4 a.m. They observed a plainclothes ICE officer move the seven detainees, 7 women or femme presenting people, into a big white van that was a federal vehicle. And then they followed the vehicle, observed the vehicle going to the Burlington Airport. We're able to get some video footage and photos of people, of the ICE escort taking the detainees out of the van and escorting them through security and upstairs, where then they were sitting. Everyone was in plain clothes, so I'm not sure that commercial yeah, like I think a trained eye would see it, but I don't know that it was necessarily apparent to the other, commercial passengers that were in the airport. It's a busy time of day in the Burlington Airport. But they were sitting and waiting for their flight. It was United Flight 1851 to Chicago. The legal observers got me on the phone and asked if I would be willing to spring to the airport, if they, were given the opportunity to pause the flight or something to, if the detainees wanted access to quick legal orientation, know your rights or something. I let them know that, like, without a judicial order, staying their relocation out of state, pursuant to a habeas corpus litigation, that, there was nothing I could do to stop the flight. And we should try our legal tools in good faith before we start doing other weird stuff. But they attempted to try and get the airline to voluntarily hold the flight. They were attempting to escalate to the managers. In the end, the airline felt that, rules prevented them from being able to speak with the legal observers any further, and that they didn't have authority to stop the plane, and that they referred to the detainees as specials, presumably to avoid drawing attention to the fact, in front of the other passengers, what was going on. But it just so happens that a former representative from Bennington County, Kaya Morris, is on this flight going home to Chicago to visit family. And so she decided to go live on Instagram and to share about what she was observing. And there was, this idea among the legal observers that maybe, like, people would hear and see and know about what was going on, and maybe people would want to voluntarily disembark because they didn't want to be on a United flight that was relocating ICE detainees for no discernible reason, in this, like, clandestine way. And the plane was delayed, but not enough to trigger Department of Transportation regulations that allow a person to choose to disembark. So there was no, like, further action. The plane is in flight right now, and Kaya Morris has generously offered to stand by after she disembarks and deplanes to wait and observe and record anything she can about the deplaning of the ICE detainees who have been brought to Chicago. I don't have any other information about, like, who they are or why they're going to Chicago, whether that's their final destination or if they're being removed expeditiously from Chicago or transferred to detention facilities elsewhere in the country. I don't believe that any of them are the people that got booked yesterday. So it's just to give you a sense, like, about, the scale of how many people are being held in Vermont in different facilities. So that's kind of the big picture of, like, just a snapshot of the last 24 hours of who we've got. Source that also confirms, right, this there's another person in Springfield, so we can, and then there's also data gathering happening in the advocacy community and also in communication with the Department of Corrections. So it's not like we'll be able to keep track of and report on numbers of ICE detainees at any given moment, in a way that is, like, informative of our legal work very soon. But that's the tea. That is what happened. Questions, comments, concerns, corrections? Okay.
Hi, can you hear me?
Yes, hi, welcome.
This is Chip Wadhams. So I got in a little late, with apologies. Is there anything we can do now? Do you want us to just stand by? Do you want us to go anywhere? Do you want us to do anything?
Perfect segue, Richard. So what I would like to do is, with our remaining time, I would like to quickly orient this group to what the process of, providing on the ground legal screening and orientation, what it looks and feels like here in Vermont. And then answer questions. We can do a little bit of collective brainstorming. And then I hope that for folks who are feeling intrepid and motivated to press print on our screening materials that we're putting together and go to a facility and try to exercise your attorney rights to offer to meet with the detainees who are being held there, I want you to have the tools to do that comfortably. And know that I'm not physically, I let folks know I'm not able to physically go on the ground today. And I promise my staff that we're not taking any more cases right now. And so I shouldn't be anywhere near any of the facilities right now. But I really appreciate you all. For folks who are willing, it would really be tremendously helpful to have you do that. And for folks who are here, as with multilingual language skills, it would be amazing to either have you be willing to go under the auspices of VAAP as a legal worker volunteer, or to pair up with an attorney or legal worker who's available and willing to present at a facility. So quick 10,000 foot view. ICE, under federal law, ICE gets to detain people who it is charging with removability. It has discretion to do that. The reasons that justify detention are to protect the community pending a person's removal proceedings, protect national security pending someone's removal proceedings, or to mitigate the risk that the person is going to abscond and no longer participate in their removal proceedings as they're required to, right, and go off the radar. There are laws that have been expanded in the Trump administration that require mandatory detention for people with certain kinds of fact situations, certain serious criminal convictions, things like that. That list was really expanded in January with the Lake and Riley Act passage. But otherwise, if you're not mandatorily detainable, then you have a right to request an immigration judge to review ICE's custody decision. That is what we often in practice call a bond proceeding. You file a motion for a custody redetermination hearing before an immigration judge, and that gets scheduled expeditiously. The department you make your motion, you present your supporting evidence. The burden is on the department to make a case for its custody determination. And then the burden shifts back to the respondent or the detainee to show why continued detention is not appropriate in this case. And there's emerging case law on this that, the Board of Immigration Appeals, which is the administrative appellate body in the Department of Justice that hears immigration cases, has issued an unprecedented number of binding decisions in the last couple of weeks, a lot of which seems to be directed at curtailing efforts like this one to mobilize bond litigation capacity. The BIA seems hell-bent on making it more and more difficult for people to be able to secure bond, but there have been some favorable decisions too. Brett Stokes, who's a professor at Vermont Law and Graduate School, was just reviewing his read on one of the cases, and I think his reading is a good argument and can actually have a favorable effect on people asking for release. But you make your case. These aren't really legal arguments. They're more factual arguments in the absence of a criminal legal history. If there's a criminal legal history, then there's more legal analysis around whether or not a person has what kinds of convictions, what the legal effect of those convictions are, and that requires a little bit more legal expertise that Brett and Don Siebert, Prisoners' Rights Office, are kind of the two crim-im analyzers that we at VAAP collaborate with most closely. So you show that you're not a flight risk or a danger to the community or a security risk to the country by presenting evidence of all of the positive equities in your life. If you have ties to the community, then you need to document them in any way possible. You want to seek witness affidavits, statements from employers, from clergy, from neighbors, from the school, any evidence that you can show about you being a good worker, holding down a job a long time, having been promoted at your job, being a business owner, participating in community or family life. With or without work authorization, by the way, being unauthorized has no prejudicial effect on how favorably a good work history will weigh in a bond proceeding. So it's good to have a good work history, whether or not you are work authorized. Unauthorized work does not matter here. The challenge with substantiating unauthorized work history is, especially in this climate where there's been a reported uptick in I-9 enforcement with employers, right? The department going after employers to make sure that their I-9 work authorization verification paperwork is up to date, at the risk of civil penalties. That has employers a little bit more scared. They're a little more on alert. And I think they've always been reticent to participate and, to provide a cooperating witness letter or testimony in a proceeding like this. And so part of our advocacy work in a bond hearing is really like bringing these witnesses along for the journey about like helping destigmatize what testifying in support of someone's bond motion, what risk there is to them, the benefit is to client, and the fact is, so far in my years of practice, which is not that many, but I practiced all through the first Trump administration, and I'm practicing now again in this Trump administration. I have never heard of, and someone else correct me, but I have never once heard of an employer experiencing adverse consequences incident to cooperating in someone's bond evidence packet, like providing evidence. And I don't know what the future holds. I don't spend a lot of time divining what the administration has planned for us all. I recommend making decisions based on the best information that we have available to us on the day. And we can say with certainty that the benefits to detainees exponentially outweighs risks to affiants who have a chance to provide testimony in a confidential proceeding that could mean the difference between someone's detention or their freedom. And just to put a fine point on how dispositive detention is on the outcome of someone's case, there is ample data that shows that once a person becomes detained, they have single digits percent chance of asserting a claim, let alone prevailing the claim, let alone getting access to counsel to represent you in litigating the claim. And that's the strategy. Right. It is very expensive to exhaust someone's due process rights from the perspective of the government trying to achieve a mass deportation event. The most resource efficient way that the government could achieve that goal is by detaining someone, relocating them to a facility that's far away from their community, from their lawyer, the lawyer that they already had in mind. Like a lot of people know to call VAAP if they become detained. To isolate them from their families and then to scare people into self-deporting, to make people feel hopeless, to exhaust people with detention. And we're seeing that, right? The Pleasant Valley 8 that VAAP and Brett's Clinic, the CJRC co-counseled the bond hearings on, I think it was like a 50-50 split. Half the people had bond, were offered bond, and half the people were deemed to either be a flight risk or a safety threat or whatever. And those people have appeal rights, right? The judge negates your bond request. And if there's a significant change in circumstances, you could renew your request. Really, functionally, you get one shot at the bond hearing. You could also appeal to the Board of Immigration Appeals and request their review of what you think is an error of law. And it takes a long time. Like, BIA appeals can languish in the system for a really long time. And so many of the Pleasant Valley 8 elected to go home, right? They were like, this isn't worth it to me. And it's totally up to someone to decide. But that's the point, is that what ICE is trying to do right now is to remove people's voice and choice to keep people from even understanding what is happening to them, scaring people into waiving their rights from an uninformed place, and possibly denying people the opportunity to fight their cases if they want to and exhaust their rights with us standing by their side while we all weather the storm of this administration with the hope of freedom from detention one day. And when I say detention, it's prison, right? ICE beds are just prison beds. It's just straight up prison. You're like shackled in prison without a criminal charge. That's what ICE detention is. And so I would never substitute my judgment for a client's. It's not my business to judge my client's choices or to make choices for them. But my goal in calling this meeting today is to create a framework so that advocates with clients' human, constitutional, fundamental rights in mind can be the ones to help orient detainees to what is going on right now in their lives, what their options might be, and how they can make informed decisions for themselves about next steps. We cannot let ICE be the first or only source of information on these detainees' constitutional rights. I'll pause. Pregnant pause while I have a sip of water. Questions, comments, concerns? This is fair warning. This is now the part where I'm going to put Brett and or Seth on the spot and ask you to kindly share about your experiences. Liv Barrelson, who's done this work in New Jersey detention centers, I see you. So I'm going to take a sip of water and let one of you brave souls volunteer so generously to share with the group about one of these cases you've worked on.
Well, if there's no other takers, I'll go first. Everybody hear me?
Yes.
Okay. So, if you're a lawyer and you've had like more than just a tiny little bit of trial experience, the substance of doing a bond hearing, I don't think is that hard. And maybe I'm a little overconfident because I've never done one. I got my first one coming up on Thursday. But you compile all the evidence and you send it in. The part where I've had a problem is just navigating all the crazy internet filing stuff. And that's because of my warped skill set. But Jill helped me a lot with that. And I got everything filed. There's so many aggravating factors. So for instance, you go online, you got to be registered, of course, with EOIR in the ECAS system, blah, blah, blah. And, you click all the buttons and, I looked my guy up on the locator and it said he had a master calendar hearing. Didn't say he had a bond hearing. And so everything I filed got rejected because he was actually having a bond hearing, even though the website said it was a master calendar hearing. So it was just really irritating, but all that stuff got done. But in terms of the substance of it, I mean, Jill already went through some of those factors. There's the mandatory holds for certain kinds of criminal behavior that applies to, few or none of our clients. And then there's the factors that the judge uses to evaluate what the risk of flight is, which includes things, I made a list here: fixed address, length of residence, family ties, employment, record of appearance in court, criminal history, history of immigration violations, attempt to flee prosecution, manner of entry, immigration relief avenues, community ties in general. And you just put all that stuff in a legal and a factual filing. You get affidavits from people in the community, American citizens who know this person and support this person. Typically for our clients, it might be people in the various immigration help agencies like NECASAN and CVRAN and all the other ones. And you get affidavits about, how they know the person and that the person's responsible, and all kinds of things like that. And then you really should win the bond hearing, I would think, because you show that there's no risk of flight. And there's no national security threat. There's no public safety threat because of no criminal behavior. And I did watch Brett do his, which gave me a lot of confidence to the one I'm coming up with. It's kind of a, it's not really a full evidentiary hearing. It's kind of like a truncated, quick hearing. I don't know. I'm comparing it to like, I used to do a lot of parole violations and probation violations, and they're not even quite as formal as a probation violation. They're more like a parole violation. It's a little loosey-goosey, and there are evidentiary rules, but they're brief, and you get a decision right on the spot. My question, though, I want to follow up with a question. So these people that got detained up in the Northeast Kingdom yesterday, I'm just hazarding a guess that they're probably undocumented. And I'm wondering about bond hearings. You know, they're still eligible for bond, but I know that their manner of entry is going to be held against them. I'm just curious about what's the success rate for people that are completely undocumented and, you know, have totally escaped detection and just get rounded up in an ICE raid. If anybody has any experience with that, I would like to know about that.
Thanks, Seth. I'll introduce the concept that Seth is alluding to, just to help inform the conversation as this develops. So there is a part of the immigration law. There's a whole section of the immigration law that deals with removals and removal proceedings, right? Half the immigration law is about how you gain status or gain access to the right to have rights. And then the other half of the immigration law is about how you lose the right to have rights, right? The circumstances under which the government can and will take away your status, your right to have rights. And there are procedures to ensure due process in two parts of the statute, INA 235 and INA 240. We should really be getting CLE credit for this, by the way. Maybe I'll ask for it retroactively. So under INA 235, that is a procedure for expedited removal. And the idea is, you know, the Supreme Court has held over the years litigating the Chinese exclusion cases that, like, yeah, if someone has recently arrived and they're at the border, this is an exclusion proceeding, not a deportation proceeding. And so your expectation of due process should be lower. Like, you are owed less process if you haven't yet entered and you're just being excluded from entry versus someone who's in the interior and being detained and deported. And over the years, that exclusion has encroached more and more inside of the US border. And as a result of both legislative and policy changes. So when the Trump administration took power, one of the policies that they put into place, you know, they've been hitting us, flooding the zone with all different kinds of policy changes, some of which are blatantly illegal and some of which might withstand judicial scrutiny, is a way that I, as an advocate, would say it. I, as an immigration law professor, would say, yeah, they can totally do that. But they, you know, we're going to implement expedited removal to the fullest extent under the law as we read it. And so nowadays, what that looks like is the Trump administration defines a recent arrival as anyone who can't show that they have been in the United States for 2 or more years. So what Seth is alluding to is there are people who have been here for 2 whole years, living in the interior, establishing lives, maybe having children, everything, right? Like deep ties, who Trump is saying you don't get the benefit of a full due process, a full removal proceeding under INA 240. We're going to treat you like a recent arrival by virtue of how recently you arrived. But exclusion was originally conceived of as someone like arriving at the border and saying, hi, I'm here, can I come in? And now we're saying a person can establish their entire life within 100 miles of any land or sea border. That's almost the entire state of Vermont. It's like the majority of the US population lives in that 100-mile border zone. And we're saying anyone who can't show that they've established their lives 2 or more years could instead, you know, the test is we don't have to give them so much process, not so much process is due. We could put them into expedited removal proceedings, and instead of going before a judge, the department gets to just bootstrap itself and say, you're deported, goodbye. And so what Seth is flagging is this practice we've been hearing about in the news for the past week or 10 days, including at Chelmsford and Boston immigration courts, where the Department of Homeland Security is moving to dismiss 240 removal proceedings. They're the ones that prosecute the case, right? And they brought the removability charges, ICE counsel. And now they're saying, actually, judge, never mind. We withdrawn. We don't want to prosecute this. Can you dismiss the case? Because we've realized that this person has been here less than 2 years, and we want to arrest them and put them through 235 expedited removal proceedings so that There's no accountability or recourse. So we're seeing this happen. That's what, when you hear about ICE arrests happening at immigration courthouses, it's for those recent arrivals, which includes like the vast majority of the people who VAAP has helped file their initial asylum. So we're watching that situation. I don't know yet, Seth, what's happening. The other thing that I shuddered into existence is a risk. I'm not like the genius who thought of this. I've learned about this from national partners. But this idea that we've seen in Vermont an uptick in criminal prosecutions for unlawful entry and alleged harboring and smuggling. And there is also an uptick in people just being taken into federal criminal custody and pleading out that way, and avoiding immigration proceedings altogether, like kind of going to the criminal system first. And unlawful presence is not a crime, but the act of unlawful entry is criminalized in the federal code. And Trump has just issued a policy that makes people exiting that kind of criminal custody mandatorily detainable by ICE, ineligible for bond. So anyway, all that is to say, yes, I see on the horizon how bond alone is not going to be enough to save our community in this moment. I think that bond is a really effective and accessible place for us to start. While we work with the impact litigators who tested habeas corpus litigation on Mosin Madawi and Rumeza Ozturk and think strategically with people who make the big bucks, pay grades much higher than me, brains much better than mine, think about how to scale that as a legal service for a mass amount of people. Because Mosin and Rumeza each got hundreds of hours on those two habeas cases. They were successful and they're still being litigated at the circuits. And that's not a scalable service that we can offer just yet, but we're thinking about it. So that's the answer to the question, Seth, is I don't know. But you're right to spot the issue.
Well, can I do a follow-up question? So now I'm a little bit concerned. So even if you've got an avenue of relief, if you got your asylum case pending, you've been here for less than 2 years, the government, I'm just like, I'd be shocked if the government gets away with this. When you have relief pending and you're in removal proceedings, they're just going to like, I get it for like the undocumented people that can't prove they've been here for 2 years. But somebody that's got it already has an A number and has an avenue of relief and has a support system, they're going to try to pull the same trick and they might even get away with it.
I mean, I think that for the respondents, for the clients who are like want to fight and can fight, that's their circumstance, and are willing to spend some time in a facility to make that possible. I agree with you. I wouldn't be here. I would just be like lighting fires if I didn't believe that the rule of law can be saved. Like if I didn't believe in these legal tools, I wouldn't be here like wasting all of y'all's time. And so I do have hope, right? Like I do think that I really think that we can hold the line. I do think you're right that there are going to be some motions to dismiss that get granted and there will be people deported, and that's already happening. However, the National Immigration Bar is already gearing up technical assistance to help removal defenders like all of us now, because you're all getting trained and you're all on board, to oppose motions to dismiss presented by ICE for this reason, especially for people who already have applications for relief pending, right? Because there's just no way, like our whole fabric of rule of law can't sustain. We don't want to have to hear your asylum case that you're guaranteed a right to bring under international and federal law. So we're just going to do this like bullshit to dismiss your case so that we don't have to hear it. Like, I agree with you. There's just, I mean, like, I feel like our constitutional democracy is in trouble if that is allowed to withstand on like a systemic level. I do think on an individual basis, we're going to win some and we're going to lose some. And so we have to steel ourselves. That's why at the top of this meeting, I set, wanted to lay out for the group what I think success looks like. I think we have to be really clear with each other at different stages of this Trump administration of what success looks like. Because sometimes it will look like a plane of women getting flown on a commercial United flight next to someone Instagram reeling them like they don't like it's just another flight, and there's nothing that we can do about it, and they will be removed, and that's going to happen. And I think like we're going to lose battles, but I think we can hold it down and win the war.
And isn't there a fundamental problem with since technically you're supposed to file your asylum application within a year of coming over the border. So basically anyone anyone who timely files an application for asylum is removable because they've been here less than 2 years.
Well, people are removable if they don't have status, right? Like there's a lot of like language, like charged and pejorative language that people talk about to try and distinguish subpopulations. Like there are undocumented people and asylum seekers and deportable people or quote unquote illegals or other words that are actual slurs that I'm not saying out loud. And right, a person who is removable, like being removable has absolutely no prejudicial effect on your right to seek asylum. All you need to do is physically be here and physically be afraid.
No, but what I'm
trigger your
saying
right.
is that the very fact that you filed your asylum application in a timely manner, unless, several years have passed by since you filed, the very regulations that you're following are now grounds for getting you kicked out. And that seems problematic.
Right. Totally. I mean, there's like regulations about, there's so much about it that's so antithetical. It's like, so are we supposed to be telling people to go to their hearings or not? Because if you're sitting there arresting people before they've had a chance to lodge their appeal on the dismissal of their removal proceedings so that you can expeditiously remove them instead of giving them the opportunity to appeal as is their right. Like, so I am a lawyer, what? I'm going to tell people to go to court? I'm not allowed to tell them not to because the regs require them, right? It's just like, so much of it is you're so right. It's so absurd. And so I do think, like we've seen with like the flood of executive policies, some of which are like so blatantly illegal and ridiculous. But the thing is, they're all out there and they're in writing. And unless and until we challenge and overturn everyone, right, they continue to be kind of out there. And people will begin to acquiesce, preemptively comply potentially for fear of retribution. So I appreciate that nuance, Rick. There was a question in the chat about, well, okay, why don't we do this? Let's pivot to Brett. Thank you, Brett, for being willing. I know Brett has many little babies, and I can't imagine doing this work and also parenting lots of amazing small children who rely on me for a living. So you're amazing, Brett. If you're willing to unmute and share, first of all, about, just like a general, like, what's your take on your experience with bond litigation? And then particularly if you can comment on bond litigation for people who have been detained as a result of criminal legal histories.
Assuming everyone can hear me until I hear otherwise, but
we can hear you.
Excellent. First of all, great to be here. Thanks, everybody. Hi, everybody. And sorry I'm off camera, but my take on, I think that we've already talked around this a little bit, so I'll keep it brief, but my take on bond stuff right now is it's definitely a great avenue. Whenever I'm dealing with a detained case, I break it down to either my clients or prospective clients or whoever I'm talking to from the perspective of there's these two separate and parallel tracks of custody and removal, and we need to think about them as two separate tracks. And my goal first, / probably their goal as well, is to focus on track number one, which is custody, and getting them out of jail as quickly as possible. So that's always my basically primary goal. But at the same time, it's necessary to be triaging what type of relief folks are eligible for. I'll just say a little bit briefly about the recent, I guess, I hesitate to call it a shift, but there's some hostility now towards just custody redetermination in general. In the past, we're seeing a lot of people being detained right now that in the past probably would not have been. I have represented many people already this year in these types of proceedings, and none of them have criminal histories, which is just shocking to me that we're having these conversations about that, because in the past the issue has always been danger. And so if we're not talking about that and we're just talking about flight risk, I don't know what the conversation's about. So that's my 2 cents. For the most part, basically, the shift now is that while detention in the past typically was reserved for, in my experience anyway, people who could foreseeably be deemed to be some sort of danger to the community or otherwise violated a term of their conditions of release, is now really, it's fair game for everybody if you are undocumented. So it's important to be moving forward, and the hardest thing right now is just the speed at which folks are getting moved out of state. But the name of the game is trying to get things moving as quickly as possible so that the cases can get venued here rather than Louisiana or Texas, or wherever they're ending up moving folks. But to respond to a quick question that was in the chat relative to like criminal histories and those sorts of things, what's the best way to verify that? And then there was a question about discovery. There's no discovery. ICE would never in a million years ever share any information or documentation with you ahead of time. You literally have to FOIA it. So the best and only way to get the information about criminal history is from your client directly. So let's say hypothetically, in a perfect world, they have lived only in one state or only in Vermont, and they have like some stuff in Vermont. Either you with elevated access or somebody that you know who has elevated access can like pop on there. Actually, I don't even know if you need elevated access to just see what the charges are and stuff. But anyway, getting on the public access portal and verifying criminal history for Vermont is one way. Otherwise, it's identifying, okay, go like walking through arrests, contacts, those sorts of things, and just stressing how important it is. In my experience, in doing this for many years, like my clients are, there have been very few instances where I have gone to like a custody hearing and been surprised by a charge that I didn't know about. So the clients are generally very good historians about when they've been arrested, and sometimes it might require a little bit of prodding and like asking questions creatively to figure out, because sometimes they might have an understanding that like, oh, well, I don't need to talk about that because it was just a ticket, but it was a ticket for like disorderly conduct or something like that. So at the end of the day, it's really just about how you ask the questions. But I wish that we would get like a printout of something, but you're not gonna get that. And yeah, those are my 2 cents for the time being, and good to be here. And I was just, one other thing while I have the mic, I'm just curious about if there's any kind of what the game plan is in terms of rolling out to facilities or not. Just curious about that, because I'm probably going to plan on heading to Northwest State today to chat with folks. So I would love to just kind of get a vibe or gut check on, I guess, who else is coming. Okay, thanks, bye.
Jill had to step away, so Liv, are you able to share your experience in 2 cents per Jill's comment in the chat?
Yes, I wasn't sure if people are going to respond to Brett verbally or in the chat, so I didn't want to bogart that. I don't know if I have like all that much to add after what Seth and Brett have said. Most of my work in Jersey was with people that did have heavy crim for bond, so it's like, as you know, Brett was saying, it's becoming more common for people with no crim to be detained, which is strange. But yeah, I mean, I guess my only things I would add is, you know, for the supportive bond packet, it's really helpful to have, you know, the letter from the bond sponsor, obviously, but also like a social work letter or like a social work plan. You know, say your client had some sort of infraction related to a DUI. You know, we are here to ensure that client will attend Alcoholics Anonymous. They have access to therapy. We are here to provide case management support. We'll make sure they do not drive, you know, stuff like that. Also, like, I know it sounds kind of manipulative, but like letters from clients' children I've found have been like effective depending on the IJ if they have kids of a similar age themselves. And I think also with a lot of IJs, even if like it's a, I don't want to say bogus charge, but like sort of in that direction, they don't take super kindly to being like, oh no, like my client didn't do it. Like you have to just go more in the direction of like, yes, we understand this is like the worst thing that ever happened. He had one beer and was sitting in a stationary vehicle, and like no one could commit a worse crime, but he will be in AA. And you know, sort of in that direction, at least has been my experience. And then just looking at the IJ themselves, like doing your background research on like what kind of person they are, like what kind of stuff is like really their pet peeve, what kind of stuff they tend to grant, I found to be really helpful. Like if you know this IJ really likes to see, you know, someone being remorseful and committing to programs, or like, you know, this person doesn't like, you know, whatever. Yeah, so I think that's it from me, but I'm down to if anyone has questions about bond packets.
Perfect. Thank you. And thank you, Sydney. Thank you all. You're all geniuses, and Penny should stop barking now. Judah, what do you got?
Hi. From listening to this, I see, although I wish I could do more, I'm not licensed in Vermont. So I guess I can't go get in the prison today. But I know Steve Crofter, who you may know, and he couldn't attend this chat, but he's very willing and able to be an interpreter. How does, if somebody lawyer is going to go to Springfield today, how could Steve get in touch with that person to act as an interpreter if they need one?
Thanks, Judith. And thank you for the question. And it sounds like you're kind of echoing a theme that Brett introduced of like, it sounds like people are maybe ready to start to talk about logistics a little bit. So let's talk logistics.